If you invent something at work, who owns the invention? Does your employer own the invention, or do you own it? Let's take a look at this in today's video. Hi, my name is John Farrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. When you invent something in the United States and file a patent on your invention, by default, you, the inventor, are the owner of the invention. Whether you're inventing for a company or whether you're working on a fishing lure in your basement, the default position is that ownership goes to the inventor. I call this the inventor takes all rule. Now there are three important exceptions, and we're going to talk about these three exceptions now. Now the first exception is when there's a written agreement between the employer and the employee. And I have to tell you, this is a big exception. Experienced companies almost always have written invention assignment agreements between their employees and the company, assigning the inventions to the company. The language in these agreements typically says that the employee agrees to assign all worldwide rights, title, and interest in any and all of his or her inventions to the company. Some of these agreements limit the scope of this assignment to inventions that are made at work or relate to work. Others of these agreements are much broader and attempt to capture inventions by the employees that are completely unrelated to the work that they're doing. But it's important to understand that these invention assignment agreements are often negotiable, and it's very important that if you have inventions that you've come up with or filed patents on prior to joining the company, let the HR department know about these and see if there's some rework that can be done on the invention assignment agreements that are appropriate for the work that you're doing and the prior inventions and ideas that you have. Also, state laws in many states limit the scope of these invention assignments. It may make sense to consult a patent attorney in your specific state. As an almost humorous aside, but not so much at the time, many years ago, I had a client who was started as a startup company and grew to be a much bigger company. And after making an invention, one of their engineers refused to assign ownership of her invention to the company. So when consulted about what to do in this situation, of course, the solution was simple. Just get the employee assignment agreement in the original employment agreement, and we would file that along with the patent to demonstrate ownership by the company. But unfortunately, in this case, the HR department had lost the password that contained the employment agreement documents for all of their employees. And we were unable to access her employment agreement to record as an assignment of the patent. For all practical purposes, this company had no employment agreements for its several thousand employees at the time. Now, the second exception to my so-called inventor takes all rule is the common law doctrine of hired to invent. The hired to invent doctrine says that if an employee was hired to solve a particular problem or to invent a particular thing, then the company owns the invention and not the employee. It's important to note, however, that the hired to invent doctrine has been fairly narrowly applied. At least one federal court in California has stated that the hiring must be for a special purpose, and that an engineer who was hired to work on multiple projects is not covered under the hired to invent doctrine. Now, if you've followed some of my other videos on copyright law, you'll note that this hired to invent doctrine is sort of a kissing cousin to the work for hire doctrine in copyright law. In copyright law, if an employee is brought in for the purpose of authoring a creative work, then the work for hire doctrine might apply. In this case, the inventor is brought in for the specific purpose of creating an invention rather than authoring a work. Now, it's also important to note that the hired to invent doctrine is not self-executing. When the inventor makes the invention is owned by the inventor. And the only way for the employer to get access through the hired to invent doctrine is to have the inventor voluntarily assign the invention to the company, or to get a court order, and we call this a constructive assignment, get a court order assigning the inventor's or the employee's work, the employee's invention, to the company. Now, obviously, this is a messy process, and it underscores the importance of having employment agreements between employees and employers. Now, the third exception to the inventor-takes-all rule occurs when there's no written agreement between the employer and the inventor. The inventor was not hired to make inventions, and the invention was at least paid for partly by the employer. This third exception is called the common law of shop rights. Shop rights is the recourse of last resort. You get to it only if there's no written agreement and the employee refuses to assign the invention to the company. Now, as you might expect, because this is a remedy of last resort, the rights that the employer gets under the shop rights doctrine are somewhat limited. Now, the contours of the shop rights doctrine differ from state to state, but generally speaking, if the employee develops the invention using resources and time and as part of their work for the company, the employer or the company is entitled to continue using the invention even when the employee leaves. However, it's important to note that this continued use by the employer of the invention is a non-exclusive use. That is to say, the inventor can take that invention with them and use the invention at the next employer or license that invention to others to use. And probably most importantly, this non-exclusive license that the employer has in the invention is non-transferable. That is, if the company is later acquired or the company tries to sell the invention to others, this license to use the invention may not pass with the sale of the company. And so for at least this reason, shop rights is a pretty weak ownership in intellectual property. Okay, in summary, as between a company and their inventor employees, the inventor by default has ownership of the invention. Now, there are three major exceptions to this. The first exception occurs when there's a written agreement between the company and the employee. This typically arises at the time of employment. When the employee is brought on, they're asked to sign an employment agreement in consideration of their employment. And in this employment agreement, there's a transfer of future inventions from the inventor to the employer. The second exception is the hired to invent doctrine, where an inventor is hired to work on a specific problem or to create a specific invention. And the third exception, the exception of last resort, is the shop rights doctrine under common law, which gives the employer limited rights in the invention even after the employee leaves the company. Understanding that depending on the jurisdiction of the company, those rights in the invention are probably non-exclusive and likely non-transferable. Now, if you found this video useful, I'd appreciate it if you'd like and subscribe, and I think you'll find this next video helpful as well. I'll see you over there.